Section 16 of the Companies Act 2013 deals with the rectification of name of the company. Definition: Section 16 deals with the rectification of name of the company. If a company is registered with the name that is identical or too closely resembles the name of an existing company or a registered trademark, the central government may direct the company to change its name. Okay, सिंपल वर्ड्स में अगर जो समझा जाए हम लोग, तो if a company gets registered with a wrong or conflicting name, the government can orders to change that name. Okay, फिर नेक्स्ट अपने चलते हैं सेक्शन 16 सबसेक्शन 1 क्लॉज ए, name similar to existing company. If in the options the central government, the company's name is identical to or too nearly resembles the name of an already existing company registered under the Companies Act or any previous company laws, then the central government may direct to company to change its names. Requirement: Company must pass an ordinary resolutions. Name must be changed within 3 months from the date of directions. For example, suppose ABC Technologies Private Limited already exists. Another company gets registered as ABC Technology Private Limited. The central government may direct the second company to change its name. Section 16 subsection 1 clause B, a name similar to the registered trademark. If a registered trademark honors applies to the central government, stating that the company's name is identical with or too nearly resembles its registered trademarks, then the applications must be made within 3 years of incorporation change the name, and the central government may order the company to change its names. Requirement here is company must pass an ordinary resolutions. Company must change its names within 6 months from the date of the directions. For example, a company registered as a Tata Electronics Solutions Private Limited without authority. The registered proprietors of a Tata trademark may apply to restrictions rectifications. If the government agrees, the company will be directed to change its name. Section 16 Section 16 subsection 2 deals with the notice to registrar. After changing its name, the company must inform to the registrar of the companies. Notice must be given within 15 days of the change, and the order of the central government must also be filed. ROC will make necessary changes. Certificate of incorporation and memorandum of incorporation is required. Section 3 Section 16 subsection 3, penalty for non-compliance. If the company fails to comply with the directions, company liable to penalty of rupees 1000 per day, during which the default conditions and officers in default penalty not less than 5000 and max may extend up to 1 lakh. And after that अपने जाते हैं Features of the Section 16: Protections of the company identity, protect trademarks rights, and government oversight. Central government has authority to direct rectifications, mandatory compliance, and legal certainty. Advantage of the Section 16 is prevent public confusions. Customer can easily distinguish between companies. Protect goodwill. Existing companies do not lose business because of similar name. Trademark protection. Registered trademark owners receive legal protections. Fair competitions prevent companies from taking unfair advantage of established brands and strengths Corporate governance maintains transparency and credibility in company registers. Disadvantage of the Companies Act 2016 is cost of name change. Changing company name involves legal and compliance cost. Rebearing expenses, the company may need to change websites, stationery, logo, and marketing materials. Administrative burden. ROC files and procedural formalities must be completed. Possible business disruptions. Change a well-known name may temporarily affect the business recognitions. The key takeaway from this section is ensure that every company has a distinct identity, protect trademarks rights, and maintain a fairness of the corporate world.